Good evening. This is John Milburn, Laws 12062, Alternative Dispute Resolution. This is week number 6. Tonight we're dealing with arbitration. We have the first assessment piece that is due in week 8, which is the 8th of September 2016, and the assessment is due at 11:45 p.m. Many people have already submitted their work, and thank you very much for doing so. I'm aware that you've submitted the work, but I haven't looked at the work. What I do is, as much as possible, look at the work one after the other, and I generally look at the work in a random manner. So I don't start alphabetically and work through. The way in which the system works, it generates a random way of marking the assessment, and that's what I do. So for those of you that have submitted your work, thank you very much for doing so. I am going to ask a favour of those of you who have submitted your work, and that is either through email or perhaps through UCrew. If you want, make yourself available to assist parties that might be struggling to find participants. Every year we find that there's been some communication problems or people have dropped out, and they might be saying, look, I need someone to participate in the mediation or conciliation. So if you want to let me know, either through UCrew or an email to me, I'll create a list of people that are willing to come in, step in and act as a participant and play a role at the last minute. So if you do that, that's great karma, and thank you very much. We have a number of people online tonight, so thank you for doing that. And if we have any questions, please ask through the chat facility. Tonight we're dealing with arbitration, but before we do that, I'm just going to talk very briefly about the second written assessment, the take-home practical paper. This is a paper where I've given you much more time than normal in a take-home paper situation. And the reason for that is that, for example, last year, I created a scenario where the task that you had was to provide a practical advice to a theoretical client or clients in relation to disputes that lend themselves to some sort of ADR solution. And indeed, part of the task was that you actually speak to ADR practitioners, not just in Rockhampton, but wherever you might be. So I'm going to ask you to do this, to start thinking about whether you can speak to ADR practitioners to get some real experience and make a real life contact here. The experience that we had last year was that some students were met with quite an abrupt response from ADR practitioners. You're a student, you're not a paying customer, I don't want to know you. Others had a very different experience and found that the ADR practitioner was not only willing to assist with some real life guidance, but also perhaps work on the basis that you as law students may one day become customers. I don't know. So we had different responses from different people, and many practitioners, of course, were just, for no particular reason other than their willingness to help, were very forthcoming in their assistance. Now, I'm not saying just yet that your task in the practical assessment will require you to speak to ADR practitioners, but there's a fair chance, and I'll provide more hints as we progress week by week. But at this stage, I just want you to be aware that that was the task last year. You may be required to speak to ADR practitioners, so start thinking about that as a possibility. Now, if you have any questions, please interrupt, come in live. I'd rather this is a discussion rather than me simply talking. I'll go to speaker view for a moment, but if you do have some questions and you're not on camera, please use the chat facility, and I'll continue to monitor that while we're talking tonight. So tonight we're talking about arbitration primarily, and this is based on chapter 4 of your text, which is an excellent overall summary. The thing that you've noticed from the outset when it comes to a discussion about arbitration is that we are dealing with both the international and domestic law. And in the domestic law situation, we're dealing with both state and federal laws. So there's a whole match of different laws and obligations that you need to consider. Throughout the content of the reading material and the online material, as indeed the principal legislation, you'll see reference to the model law. Now, this is the model law on international commercial arbitration. I'd urge you to have a look at the UN website, and that's the United Nations Commission on International Trade Law. If you look there, you'll see the acronym is UNCITRAL, UNCITRAL, Model Law on International Commercial Arbitration. Now, that particular model law was created in 1985. It was substantially amended in 2006, and it has filtered its way through into our domestic law very clearly in the Commercial Arbitration Act of 2013. Now, that act is a piece of state legislation, but it's part of a federal initiative, and it's a law that is uniform between the states. So coming back to UNITRAL, the model law is defined on the website in this way, and this is its purpose. I'll read this to you. The model law is designed to assist states in reforming and modernising their laws on arbitral procedure so as to take into account the particular features and needs of international commercial arbitration. It covers all stages of the arbitral process, from the arbitration agreement, the composition and jurisdiction of the arbitral tribunal, and the extent of court intervention through to the recognition and enforcement of the arbitral award. It reflects worldwide consensus on key aspects of international arbitration practice, having been accepted by states of all regions and the different legal and economic systems of the world. So that's from the United Nations Commission on International Trade Law website. And what we see from that is the start of an international consensus in relation to arbitration. Now, of course, we know from introduction to law that even if our government does sign a treaty or a convention, it doesn't automatically become part of our law. It might influence our law, but it's not part of our law. So it becomes part of our law when Parliament enacts legislation to reflect the content of that international obligation. In this instance, the federal government created the uniform laws, which essentially was passed on to the states, which then passed those laws independently. Now, can anyone tell me why on earth the federal government just didn't legislate these laws at a Commonwealth level? Is anyone able
because
to?
Because of the power of each state, the Commonwealth doesn't have the power to legislate these in each state.
Thank you, Jason. Was that Jason? I think it was. Thank you.
That's correct, yes.
Thank you, Jason. Any other thoughts? Constitutional reasons, heads of power. Any others? Okay, we're on the right track. So have a look at the Constitution, Section 51, subsection 35, so XXXV. And the Constitution does not allow the Commonwealth to pass laws in relation to arbitration other than, so there is always an other than arbitration in conciliation for the prevention and settlement of industrial disputes beyond the limits of any one state under Section 51. So it's because the Constitution allows the Commonwealth Government to make laws in relation to arbitration, but only for industrial disputes, that the Commonwealth was instrumental in encouraging the states to create the and pass the Commercial Arbitration Acts. Now, of course, arbitration is a very old form of ADR. Some commentators say it's not really even ADR, it's so close to a court litigation situation. But we have the original federal legislation from, what year was the Conciliation and Arbitration Act passed federally? Any thoughts?
I think it was early 1900s somewhere, wasn't it? From memory.
1904. Thank you, Eustace. Thank you, Jason. So in this area, it goes right back to 1904, and it makes something of a lie of my statement in week 1 when talking about ADR to say this is really a recent area of practice. So arbitration, but only in relation to industrial disputes, is the exception to that general rule that ADR is a recent phenomenon, if you like, in a real sense. So let's come back to the Commercial Arbitration Act. If I suggest to you that the Commercial Arbitration Act is a bit of a misnomer, can anyone tell me what that means and why?
It applies to more than just commercial disputes, doesn't it?
Exactly. Thanks, Terry. It does. And it could probably just be the Arbitration Act. So have a look at Section 1, subsection 1 of the Act, and it says the Act applies to domestic commercial arbitrations. So it's more of a general form. It still talks about commercial arbitration, but it's got a domestic feel to it as well. And it says in the legislation that a domestic commercial arbitration is one where the parties to an arbitration agreement have, at the time of their conclusion of that agreement, their place of business in Australia, and the parties have agreed that in the dispute that has an original, it may be, that has an origin here, it may be settled by arbitration. So the interesting thing about arbitration is that this is something which is driven by the parties themselves. It is possible for the court to refer a dispute to arbitration, but mostly it's a dispute resolution procedure determined privately, even though it has many court-like features. In the legislation, the Commercial Arbitration Act, you'll see that there are a number of headings, and there's the general provisions which deal with the scope of the application. I've already mentioned that it deals with domestic commercial arbitrations, but what you will also see is that there's a consistent reference to the model laws. So when we're talking about the model laws, we're really talking about those international laws that have filtered through. And if you look at the Commercial Arbitration Act, each section actually makes a reference to the model law article from which it's drawn. So in Section 1 of the Commercial Arbitration Act 2013, when talking about what is a commercial arbitration, it refers in fact to the model law, and it says the term commercial should be given a wide interpretation. And this is why I suggested it's a bit of a misnomer, so as to cover matters arising from all relationships of a commercial nature, whether contractual or not. And relationships of a commercial nature include, but are not limited to, the following transactions: any trade transaction for the supply or exchange of goods or services, distribution agreement, commercial representation or agency, factoring, leasing, construction of work, consulting, engineering, licensing, investment, financing, banking, insurance, exploitation agreement, concession, joint venture, carriage of services of goods or passengers by air, road. So it's really very wide. It's still got a commercial flavour to it, sure, but when you look at those individual items that are referred to that amount to a commercial arbitration, it has enormous scope. And the thing that always strikes me when I'm reading legislation is to try to provide a practical flavour to it and think to myself, how can this actually work in practice? When, as a practitioner, can I use this legislation to the advantage of my client? Or, I'll give you this to think about. How can I, as a law student, thinking about what I might do for a living with my law degree, work out how I could be an arbitrator, and if I was an arbitrator, how would I deal with, how could I promote my services, and in what area of work could I promote my services? So let's think this through. If you were given a task of providing, I don't know, an idea of a business plan, a very simple business plan, of being an arbitrator and wanting to work in that arbitration field as a practitioner, how could I apply the legislation to create a business plan to allow me to do that in an area that I choose? For example, engineering. So it might be that you have an engineering background, you have the technical knowledge, you think that arbitration is a good field to get into, you feel that you would be a good ADR practitioner in arbitration. So you ask yourself, when you read that section of what is commercial arbitration, what does it mean? You ask yourself, well, how could I become an arbitrator specialising in the resolution of engineering disputes? It's just an example. So when you read the legislation, I want you to read it very actively, and that is in the context of you being a practitioner providing advice to a client in relation to arbitration, but also you as an ADR practitioner, that is the arbitrator, providing a service to potential customers that might be lawyers. Okay, any questions about what I've said? And I guess you could probably say I'm starting to get into areas that might be covered in the second assessment piece. Question from Gordon, is this a Federal Act or Queensland Act? The Commercial Arbitration Act 2013 is a Queensland Act, but it's part of a uniform set, a suite of acts which is enacted around the states. In that sense, it's a little like we have the UCPR, the uniform laws, uniform evidence laws other than Queensland. We have the corporations law, the various consumer laws. So the Commercial Arbitration Act is based on a model which has been used before, where the federal government provides the overarching concept, if you like, and the states agree on enacting uniform legislation. So I hope that answers your question, Gordon. So,
John?
Yes.
Industrial disputes, mate, are they arbitrated under the Fair Work Act and under the Industrial Relations Act, Queensland ones?
Yep, that's right. So when it's when it's an industrial dispute, that's a separate category, and you look to the federal legislation and Fair Work.
Thanks.
Okay. All right. So just going back to the Act, what I might do is just pop it on a separate screen, and I'll do that now. So if you can bear with me as I share the screen. And what you should do is now see the legislation. Tell me if I'm wrong in that regard. But what we have is the Commercial Arbitration Act. I've gone through Austlii, and there are some sections that I specifically want to draw to your attention. I'd like you to read this Act in detail. There is a Commercial Arbitration Act, but we've talked about the scope of the application, and you'll see here the reference to the model law, where my cursor is. I'd like you to have a look at Section 2, which deals with the definitions. And arbitration means any domestic commercial arbitration, whether or not administered by permanent arbitral institution. The model law is here, referred to as the International Commercial Arbitration Treaty or Commission. And there's reference to a court, the Supreme Court, but throughout the legislation you'll also see reference to other courts such as the District Court. So have an idea of, or just obtain for yourself an idea of the way in which the Act is set out, the general provisions that provide for the definitions, and note 2A, which specifically deals with the international origin and general principles of this legislation. You'll see that it requires uniformity as far as practical between the legislation and the model law on which it's based, and it says here where the model law came from. So it's really quite important that you have a look at that model law and work your way back. So the general provisions go from Section 1 through to 6 specifically. You'll see that courts are involved. So the idea of arbitration is essentially that an arbitrator makes a decision, which we call an award, but the courts still have a role to play. And the extent to which the courts can be involved is only where provided for by this Act. Otherwise, the courts don't have a role to play. So it's there, but the idea is that the arbitrator effectively takes the role of the judicial officer. The court is there for certain functions, for assistance and supervision, and that's outlined in section 6. And you'll see that there is reference there to the district court as opposed to merely the Supreme Court. And the district court will have jurisdiction if the arbitration agreement provides that that is the case. So when you're reading this legislation, I want you to think about how this works in practice. So you're thinking, all right, logically then, the Act will apply in circumstances where we're dealing with a commercial dispute as defined, which is very wide, and the court has no jurisdiction unless it's referred to in the legislation, and the legislation provides that the arbitration agreement may provide for certain things. So logically then, the arbitration agreement is really important because it outlines the position between the parties. Then we have the specific provisions about the arbitration agreement in Part 2. And the definition of an arbitration agreement is outlined there. So think about what is an arbitration agreement, what's going to be in it. It provides that it may be in the form of an arbitration clause in a contract or in a separate agreement. So then you're thinking further back. You're thinking, all right, if I'm involved in drafting a commercial contract, should I include an arbitration clause? What are the advantages of doing so? What does it look like? What should I include in it? And when would I have cause to prepare a separate agreement? Now, it needs to be in writing, but the point that I'm really trying to make here is that in this context, we're working backwards. We're starting with the international law and we're taking it back to a stage where it may be relevant for you when you're involved in assisting a client at an early stage, a drafting stage. Now, I'm just going to go to, are there any questions so far? Let's look at if I can find that chat facility.
Quick question, John.
Yes.
Has there ever been an instance where the courts have declined to hear a matter because they've said the matter is not commercial in nature?
That's a good question. I'll have a look at that, but I haven't come across any in the reading. Has anyone come across any instances where that is the case?
Just out of curiosity, not for any.
No, it's fine. No, but it's a really good question because it goes to the extent of determining when a matter should be referred to arbitration, when it should not be. It's really important that you understand this so that we can so that you can give good advice to the clients. Or, as I said, if you're setting up as an arbitrator, you want to try and have as broad a client base and work as possible. So it is a really important point, I think. Okay, I'll just go back to that screen share. When you're going through the legislation, think about the composition of the arbitral tribunal. What are the bases upon which an appointment is made? And importantly, when can there be a challenge for that? And again, it's all based on the model law. Then the competence of the arbitration tribunal to rule on its jurisdiction is important as well. And the interesting thing there is that we have a situation where hopefully you're seeing the share screen. We have on section 16, we have a situation where the arbitral tribunal may rule on its own jurisdiction, including objections with respect to the existence and validity of the arbitration agreement. So it's really very wide, and this is why it's so court-like that the arbitral tribunal has extensive power. And you've got to ask yourself when you're advising a client, would I rather have an arbitrator determine the outcome of this potential dispute or this dispute, or would I rather a court? And you've got to be able to explain that to the client. Now, to explain that to the client, you've actually got to get down and speak to arbitrators. So this is what the second assessment is all about. And this is why you've got so long in the second assessment. The reason you've got so long in the second assessment is that you may have to speak to arbitrators and actually find out what's involved in an arbitration. How much is it going to cost? How long does it take? Why would we go to arbitration instead of litigation? You've probably got a fair idea of what's involved in litigation, but if a client says to you when you're drafting a commercial agreement, should I go to arbitration or litigation if there's a dispute? There's no point talking generally. You need to be specific and you need to have your answers ready to go. So that's the point of giving you that time so you can start to speak to people or during the assessment. That's if the assessment is about arbitration. All right. So the question on here is, if we were to get a question about arbitration in the take-home paper, it's appropriate for us to use the Queensland Act in preference to the Uniform Laws. Well, the Queensland Act is really part of the Uniform Laws. So the advantage of working in the arbitration field is that you have very transportable skills between the states. So I hope that answers your question, Jessica. But certainly have a look at the Queensland legislation, but take the opportunity to compare it to interstate legislation as well. Are there any other questions about that? All right, well, I'll just go
Just
back.
one more, John.
Yes.
With those arbitration clauses, are there like a suite of the old boilerplate type clauses that people drop into contracts that you use?
Exactly. Yep. There's a lot of precedent clauses for arbitration clauses. I might see if I can find some, but if someone does come across one, please share that with us, maybe through UCrew. But and you'll see it a lot in general leases, commercial contracts, building contracts. And again, the point I'm really trying to make, and I hope I'm not repeating myself too much, but you've really got to understand the definition of what is something that could be the subject of an arbitration under the legislation, and then think about it right at the start when you're dealing with a client in that particular field. I just selected engineering as an example. So if you're acting for an engineer, you've got to understand the arbitration process in order to advise on a contract. So it's so widespread. This is really wide material. Any other questions there?
One more quick one.
Thanks, Terry.
Is there any situations that you're aware of where legislation might not allow people to choose arbitration, where the legislation might say a dispute in this matter must go to a court and cannot be given to a arbitration tribunal?
I'm not aware of it. Generally, it's driven by the wishes of the parties, and if the parties have elected to go to arbitration, then the arbitration will apply unless there's good reason why not, which is referred to in the legislation. But no, generally, I'm not aware of any specific requirement where it must go to the court. That's a really good question. Thank you. Okay.
Could I ask, please? It's Gordon.
Yes, Gordon.
Could I ask what the distribution among the various types of ADR are recommended in various contracts? So is arbitration the preferred one, or is it mediation, or do you have any information on that?
Where it's a commercial type situation, mostly it would be a reference to arbitration, but mediation is very common as well. Conciliation's quite common. When it's in a family law situation, invariably it would be more a mediation or conciliation. So it depends on the nature of the dispute. But what we're really talking about with arbitration mostly is something which is built into the original contract between the parties. Thanks, Gordon.
John, I have a question. It's Jessica.
Yes, Jessica.
I'll try and articulate this as best I can, but going through this week's material, there was some reference to tribunals being like our administrative tribunals like UCAT or the AAT. How does, throwing my mind back to doing administrative law, how does that interrelate with arbitration, which is court-like, but also those tribunals aren't, but like they're quasi-courts? Like, is there a relationship there? Is it a different kind of degree? Like, is it kind of something that's still developing and there's no like set answer? Like, what could you say for that?
I really like the way that you're thinking more broadly here, and that's what I'm trying to encourage tonight. So you're thinking, okay, we've got courts, but we've also got tribunals on one side and arbitration on the other. How are they linked, and how do you choose between them? So arbitration, I guess in many ways, is most like court proceedings, but in many tribunal proceedings, it can be very much like a court proceeding as well. So we're talking about different ways of resolving an issue using different forums, and many of them share the same similarities, same, they look the same. They have the same DNA, if I can use those terms, in many instances. They're just different forums that are available to people in relation to different disputes. And that's the hard part. When you're a practitioner and you're faced with this situation, you've got to be in a position to keep in mind all these options and provide appropriate advice. So thank you for that, Jessica.
Hi, John, you're on mute. I can't hear you.
Sorry, thank you. So what I was saying to myself is, and I'll go back to the screen share. Thanks for letting me know. This is interesting. So Section 17 provides for interim measures, and it provides that the arbitral tribunal may order interim measures. Now, I'm just going to ask you to have a look at that, and in particular, have a look at subsections 2A and B, C, D, and then subsection 3. Can you see that? I'm just going to give you a moment to go through that. There'll be a little quiz. Okay, so what we have there is Section 17 that provides very broad power to the arbitrator to deal with a number of issues by way of interim measure. And if you look at those, for those of you doing civil procedure, you can see things that create images of injunctions, Moravian injunctions, Anton Pillar orders. There's issues in relation to security for costs. There's also issues in relation to inspection and evidence. So these are all things that one would normally associate with a court, but you see that the arbitrator has power to do this. So being an arbitrator is a really powerful role, and the ability for an arbitrator to make interim orders is quite extraordinary. So are we all familiar with what I mean by Anton Pillar orders, which are search orders, Moravian injunctions, which are security orders? Yes? Okay. All right. And then, so go through the legislation, you'll see that there are also orders to, there are rules in relation to the way in which the arbitration is conducted. Obviously, the parties have to be treated equally is one factor. There's a question of how the arbitration is determined, the place for the arbitration, representation, the way in which the proceedings are undertaken through the hearing, and the way in which the court can provide in assisting the arbitrator in dealing with the issue of evidence. The arbitrator can issue subpoenas. Now, are we all familiar with the way in which subpoenas are generally issued? If you wanted to take out a subpoena, how would you do it? Anyone? So you want a subpoena, how do you do it?
Don't you lodge it with the court?
Form.
What's that, sorry, Terry?
Don't you lodge it with the court?
Yes. So what do you lodge?
I'll say the subpoena.
Yeah, that's pretty much it. You know,
Isn't it to request? Isn't it to direct a witness or someone to provide evidence or come forward with evidence?
yeah, it is. It's either a witness to be produced in person or documentation, which might be a person and documents as well. And at the start, when you're practicing law, you think, "Oh, gee, that sounds tough. How do I take out a subpoena?" Well, it's really simple. You just fill in a couple of forms, lodge it at the court, and then serve it. There are rules that relate to it. There are rules about how far you can go with issuing a subpoena. But I guess what the point I'm just trying to make is that don't be daunted by what appears to be something difficult. Sometimes it's really easy to do in practice. So if you're working in the first week in a law firm and one of the partners says to you, can you take out a subpoena in relation to the Department of Education records between these dates in relation to this child, it's really quite simple to do. But the point is that those same sorts of procedures can be adopted and should be adopted in an arbitral proceeding as well. Okay, so we get the idea that arbitration is very much like court. We need to firmly understand when we can go to arbitration. We then have to understand why we would go to arbitration. And to do that, we're going to have to get on the phone, get on a website, and find out from arbitrators why, when, how much, and how long. Those sorts of questions are important and might be important for the take-home paper. I've done a lot of talking tonight, I'm sorry. But are there any questions, because I propose to wrap up pretty soon?
Just one, John?
Yes.
Yeah. Given how close this is to court procedures for civil proceedings, is there rules of disclosure on the parties that apply in a similar sense to a civil proceeding?
There is. Have a look at, I'm just looking to see if I can find the provision. There are disclosure obligations. Look at the contract if there's specific obligations there, but also have a look at the Act. I'm looking at section 17F, which deals with disclosure, and the arbitral tribunal may require any party promptly to disclose any material change in the circumstances upon which the basis is made. And that's not directly on point, but it is there. So there is disclosure obligations. And as soon as I finish, I'll find the exact section. I'm sorry, I can't point to it immediately.
No, that's good. I just saw some ones about disclosure of confidential information, so I assume the other one's there as well.
Yeah, no, that's right. Well, it's all, I guess what really happens is this, that if you look at section 19 of the Act, it provides that the parties are free to agree on the procedure to be followed, and failing agreement, the tribunal may, that's the arbitral tribunal, may conduct the arbitration in the manner in which it considers appropriate. So generally speaking, in order to have a fair fight, in order for it to be appropriate proceedings, you need to disclose material. So I would think that in every arbitration, there'd be an obligation for appropriate disclosure. And then, of course, there's the issue of the arbitral tribunal making a determination in relation to the admissibility, relevance, materiality, or weight of evidence that might be disclosed during those proceedings. Bear in mind that in dispute resolution generally, there are obligations on practitioners to not mislead. Have a look at the Legal Services Commission against Mullins, for example, in that regard, in the context of a mediation. So there are obligations to disclose, to exchange material. That's all determined by the procedure as set out by the arbitrator. And there's the overriding obligation to act ethically and not mislead. Thank you for that question, Terry. Are there any other questions, comments? Yes, Gordon?
Could I ask, please, the same sort of principles also apply to mediation and conciliation, but insofar as that the mediator or conciliator should be trying to encourage people to disclose information, although in arbitration it's kind of legislated in there. Is it still part of the ethos of mediation and conciliation?
Look, the answer to that is absolutely. And in fact, it's so much part of the ethos that a practitioner that fails to provide relevant material, or even worse, to mislead, can be subject to professional sanction. I mentioned briefly the matter of Mullins, and there's also the matter of Garrett. So I'd ask you to have a look at those cases. I think they're probably referred to in the legislation and something we might deal with down the track in terms of legal issues. But in short, in Mullins' case, for example, in the context of a mediation, the practitioner failed to disclose that his client was suffering a terminal illness, and the amount of compensation that was being offered in that case was based on an erroneous assumption that the defendant, the plaintiff, was was not in bad health, and was calculated by reference to a number of likely years of longevity. That wasn't the case. The practitioner failed to disclose the condition that his client was in, which had a bearing on the longevity of life, and therefore would have had a substantial effect on the amount of money to be paid. So in that instance, the practitioner was held to have acted inappropriately, unethically, and I think from memory had to refund his mediation fee and or the fee that he charged for the mediation and some other things as well. So there are disclosure obligations. Have a look at Mullins and Garrett. Thanks, Gordon. Any other questions? Okay. All right. Well, thank you very much. You've been very patient with me tonight, letting me talk. A little bit different tonight style to what we've been doing in the past. And please feel free to provide me with feedback as to whether you prefer the much more interactive style that we've been using in the last few weeks, or more traditional style like we've been doing tonight. If you have any information on arbitration, please share it through UCrew. If you have any questions, please ask me, or better still, ask me and your colleagues through UCrew. For those of you who've presented your assessment number 1, thank you very much. For those of you who haven't, please do so as soon as you can, but there's no rush yet. And just remember, think about volunteering your services to act as a participant, even if you have submitted your work. Okay, well, if there's no questions, I'll end the session now. And thank you very much. All the best. We'll see you next time.